So anybody who knows me knows that I'm going to start with a couple of quick disclosures. Sorry, that was my bad. Just because I'm a compliance nerd. Well, there are some lawyers on our panel. They are not your lawyer, and nothing that they say should be considered as legal advice. We don't represent any government or government agencies, so while we know a lot of things about how these work, we're not going to be representing the official position of the Ministry of Finance, of the Department of Finance, rather, of FinTrack, of law enforcement, of any other agency. Information should be free. So if there's anything in this presentation that you want to use, we will be making copies of the presentation public. Well, if you use something, we'd love to be credited. If you choose not to do that, we're probably not going to send an army of lawyers looking for you. So get good information out there and into people's hands. In terms of what's happening, way back in 2014, we had an omnibus budget bill called Bill C-31. And in that bill, it said that dealers in virtual currency, undefined at the time, would be considered money service businesses at some point in the future. Before that came into effect, there had to be regulation that was updated. So the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, and the regulations that were related to that. That thing happened in draft form this year. This one. So what draft form means is that it's not permanent. Don't panic. Don't go out and spend $1 bajillion on a regulatory risk assessment. It is a draft. And until the beginning of September, we are all able to submit comments on that draft, which means you have an opportunity to tell the Department of Finance what works, what doesn't work, where they might have got it wrong. Any individual can submit, any company can submit comments, and I would highly encourage you to do that. So if you are looking at anything that we present tonight and you are thinking to yourself, oh, that's bullshit, oh, that's going to kill my business, oh, that's really badly written, you have an opportunity to submit comments about that, and I would highly recommend that you do so. Once a final version is published, we expect that there's going to be, according to this draft, a 12-month transition period, which means once there's a final version of the law published, it's not, hey, immediately you have to do these things tomorrow. There will be some time to figure that out and get things in place. So what does it mean to be a money service business or an MSB? It means that you have to have a compliance program from an anti-money laundering, counter-terrorist financing perspective. You need to have written policies and procedures, which basically says, here's the stuff that we have to do, and here's how we're going to do it. You need to have a risk assessment, and that's something that says, here's how my business could be used to finance terrorism or launder money, and here's the things that I'm doing to stop that from happening. You need to have a compliance officer. That's a human who is responsible for compliance at your company. It does not necessarily need to be a specialized human like a lawyer or someone with a long background in compliance, but it very much can be. And if you are one of the larger exchanges, like Coinsquare, I would recommend doing what they've done and proactively hiring someone who has a really awesome background in compliance. This is Charlene. That's my intro to Charlene.
What an intro.
She's the AML compliance officer at Coinsquare. She's absolutely fantastic. We also have the same thing that Bitfinex has done. So beside me is Peter Warrack. He's a very experienced compliance person as well, with a background in banking as well as policing. Also joining us, we have Jason Beitchman and Anna Badour, who are both wonderful lawyers, two of my favorite lawyers on the whole planet Earth. And I can't say enough how much I think it's awesome when lawyers from different shops appear on the same panel for the greater good. It makes me love you guys even more. So these are very specialized people. If you're thinking, oh my gosh, we're a startup, we only have 4 people on our team, can one of us learn this stuff and be the compliance officer? Yes, you can. The important thing about the compliance officer is, number one, that they're going to know what they're talking about, so they have to be willing to actually learn the stuff and capable of actually learning the stuff. And they also have to have enough access to your management team to be effective in that role. So you can't, for example, have someone who's your newest customer service rep on the bottom rung of your junior scale that has never met anyone on your management team who is now your compliance officer. They're going to be super ineffective. Your regulators are going to have a problem with that. You have to have training. And over here we have the wonderful gentleman who is going to be moderating our panel, who is probably one of the best sources of free training on the internet in Canada. Stephen does incredible videos. He was formerly a banker. He's now at Bitfinex. And we love you. Keep doing awesome stuff. But training, you need training for your whole staff. Anybody that touches customer funds, anyone that touches crypto, anyone that's dealing with information about your customers, you want them to have anti-money laundering training. And you need to have effectiveness reviews, which is like an audit, but for compliance. So it's exactly as much fun as it sounds, and you need to do it every 2 years. And aside from that, operationally, you're going to need to identify your customers, keep certain records, and things like that. So defining virtual currency, I think, is incredibly challenging in terms of what's going to be regulated as money service business. This is the definition in the draft regulation, and something that's not a fiat currency. So first of all, kudos to the crypto community for getting the words fiat currency to appear in legislation. I think that's kind of amazing. So that can be readily exchanged for funds, or for another virtual currency that can be readily exchanged for funds. Or Part B, information that enables a person or entity to have access to a digital currency referred to in paragraph A. So when I look at this, I think it is incredibly, beautifully, terrifyingly vague. What's not a virtual currency? So we talk about funds, and funds meaning something that isn't a virtual currency, and we talk about fiat currency. And those things are defined as being different. Dealing in virtual currency, so the thing that we say is regulated, what makes you a money service business? They don't give a definition for what it means to be dealing in virtual currency. But from what they're doing in the draft regulation, you can see that certain things are meant to be captured. So these include exchange, or sending or receiving when you're sending or receiving on behalf of another person or entity. So there's some interesting implications there. Those things, all of those activities, are defined. And there are what I think are a couple of very astute exclusions. So the transfer or receipt of virtual currency as compensation for validation for a transaction. So essentially, if you're mining, if you're validating, if you're adding blocks to the chain, not considered to be something that's covered as MSB activity, or some nominal amount that's there for the purpose of the validation of information. These are really good exclusions. I think that they are probably not going as far as they mean to in terms of having exclusions. And when you think of things where you think, that's really not money service business activity, I think I should be able to just run my Lightning node, and that should be okay, and I want more regulatory clarity on those types of things. These are the types of comments that really should be made about this draft. So a virtual currency exchange transaction, you're talking about one virtual currency for another, or money for virtual currency, and an identification requirement kicks in at the amount of $1,000 Canadian or more. I think for a lot of folks, the question that they had was, how is this different from a fiat to fiat currency exchange? So with a fiat to fiat currency exchange, the transaction amount that would trigger identification is $3,000. Large virtual currency transactions, so $10,000 or more, sending, receiving on behalf of someone else, those would be covered. What's very clearly not intended to be covered here is transactions to merchants. So if you're buying consulting services and you're paying me, then I'm not a reporting entity because I accept virtual currency as payment, with the exception of certain types of entities that are already covered. So jewelers, dealers in precious metals and stones, and real estate. So those types of companies that have to submit transaction reports for $10,000 or more in cash will have to do the same thing for virtual currencies. Politically exposed foreign persons, heads of international organizations, and politically exposed means either domestic or foreign. There would have to be a determination at $100,000 or more in terms of a virtual currency transaction. So this is very much in line with what exists for electronic fund transfers today in fiat currency. And for anyone who's sitting there thinking, oh man, this sounds like a lot, I should just move and get incorporated in Switzerland. Foreign companies that are offering money service business type services to Canadians are now going to be included in the regulation where they weren't previously. So I think that that's important. What's not, and again, what's not particularly well defined is what does it mean to target your services to Canadians? In terms of joining the conversation, we have some links here. We've posted them in the meetup group. So we have a brief survey, and the survey talks about if you were to redline this regulation, what would it look like? We're going to be submitting some comments, and we really want to hear feedback from people. That survey can be submitted anonymously. So if you're sitting here today and you're thinking, I know exactly how I would change that, but I really don't want anyone in the government to know my name, fill out the survey. I won't know who you are, but I will value your feedback. So we'll have this community event. We'll have more to come. We will be taking questions following the panel. And I'm going to ask, because we're on a pretty tight timeline, that questions be actual questions. So if what you want is to go on a super long rant about why you don't like the government and nobody should be regulated, cool, I'm totally willing to listen to you. I have very expensive taste in wine, and you will buy it for me after this panel. And from there, I'm going to turn it over to Stephen, and we'll get started.
Thanks so much, Amber. I really appreciate it. Thanks for the kind words. I don't know if it's up there, but Amber's Twitter account, you guys should all really go check it out. I think some of her tweets would make Donald Trump blush like a little schoolboy. So it's really interesting. Amber already did the introduction, so I'll just get rid of all these cue cards. But the joke's on you.
Oh, I didn't know you wrote cue cards.
I have 494 more from Vistaprint. I'm okay. So we're going to start actually with a question. I want to start with Jason. If you could change something about these proposals and amendments, the way they're written, what would be the first thing that you choose?
I mean, I don't know that I would change anything per se. There's certainly some definitions that are unclear, some wording that could use some massaging. But practically speaking, I think it's unlikely, whatever comments are given, there's going to be any significant changes at all to these drafts. They're going to come out largely as drafted, and then we're going to have to deal with them. I'm a litigation lawyer, so I deal in the courts, and we deal with statutes and regulations all the time, and interpretation is the question in the courts. So you look at a word like dealing or information, and, well, what does that mean? And you get teams of lawyers who get volumes of textbooks and other cases in order to inform meaning. So there's going to be a growing up period for these regulations. They're going to come out. People aren't going to be sure what they mean. We're going to do our best to interpret them. The government's going to take a different view in some cases. And it's a certainty in my mind, as a litigator, that litigation will ensue to try and define some of these words. So we'll go to the courts and we'll tell a judge what we think it means, and the government will present their position. And that's how we will define these terms with more precision.
How about you, Charlene? Someone that has, working in crypto and has an understanding of what some of these definitions should mean.
Sure.
What would you change?
I made some notes. I might just refer to them. I've been around this legislation for a long time, since it first was enacted for financial institutions, and I can say that my panel compadre here is correct. They're not going to change significantly, no matter how much redlining, crying, begging, or screaming that we're going to do that says it's unfair. For us, for Coinsquare being a digital currency trading platform, the definition of what is dealing in virtual currency, we know we're clearly covered under it, no matter which way it's going to be sliced. Where I'm concerned about the lack of clarity in the definition is our customers that we're onboarding, and their different interpretations of whether or not they fall under the definition. And I pose this question directly to FinTrack, about asking for clarity. We don't want it to be too prescriptive, that it puts things into a box and it's too, again, too prescriptive. As the government tries to be more, what do they call it? Something based, principles based. Sorry, thanks. That's the word. But by doing that, they leave us all in a little bit of a gray zone. So if we got two customers doing the same thing, and one says, well, I don't consider myself as dealing in because this is my interpretation, and the other one says, well, I am, and you know, we're saying, well, we want to be fair on the playing field to all people who are in our similar industries. Like, we want to be a partner with people in the crypto space, but we have to make a decision what our interpretation is. Now, FINTRAC has offered to, on a case-by-case basis, offer you an interpretation. But I know Amber's pretty familiar with how their interpretations end up buried thousands of pages deep in their interpretive notes. And there is a little bit of a lack of consistency even in them doing that now for existing institutions. So I don't anticipate that they're going to get better at it doing it for cryptocurrency, which is a market that they don't understand very well.
Amber, you were looking to add on to that?
I was just going to say, but at least those things are public now.
Mm-hmm. Yeah, there was a time where they didn't share any of that, so there was a lot of industry outcry to ask for that interpretation. If you're telling one entity, our opinion is this, but nobody else knows about it, isn't helpful. So they do publish it. It is, you know, a lot to get through. Literally thousands of pages of interpretation on their website. Although I do like the idea of putting them, you know, to task to respond back to, this is what I do I qualify? But that's not really scalable for this market, right? Like, they shouldn't have to be answering individual questions. If they could add some more color to the definition, again, without, it's a tough line, it's a delicate line to toe, to
right.
Put too much clarity. Lawyers can attest to that, right?
Anna, what's going to keep you the busiest with these proposals? Which one would you change if you could?
So I would echo the fact that persons dealing in virtual currency isn't defined. I work on the regulatory side, so I meet with a lot of businesses that are trying to figure out, are we regulated, are we not? And right now there's just a lot of vagueness there, which makes it very challenging to give advice, and also really makes it a risky decision. Because some businesses will take the view that they're not, in their view, dealing in virtual currency, but it really doesn't have the clarity that's needed for that. There is some hope that perhaps over time, both in terms of individual policy interpretations that FINTRAC gives, and then sometimes they actually bring it together into, you know, more of a write-up that's a kind of more fulsome. So maybe we will get something from FINTRAC. Yeah. So I agree, we're probably not going to see any changes or very few changes at this point to the regulations. They've been approximately 4 years in the making with finance, but there is some hope that coming out of FINTRAC we'll see something that will give clarity. And the other aspect that we haven't really talked about is the fact that the reporting requirements, they're really, really detailed and onerous, and I think will be very difficult to comply with, you know, even for large banks, let alone a smaller MSB. And I think they're not really practical. So I think over time, we do see changes from time to time, and it may not be as a result of comments immediately. So for example, the ability to identify, they've added some language that makes it easier to move to kind of a digital identification, moving away from the word original. So, you know, we do see sometimes that they may not reflect it in the revised draft in the draft stage, but if they get enough feedback from the industry, they do sometimes in a later amendment address it. So hopefully we'll get some of that, but you know, that could be many years in the process.
Peter, for you, is there anything that you kind of like seeing from a vague standpoint that might benefit you working for a crypto exchange, or is there anything that you would like to see change to help benefit what you do at Bitfinex?
Well, firstly, I'd like to thank Amber for all the work she's done in this space in particular, and Rodney and Outlier. I think, and secondly, I maybe take a slightly different view to my fellow panelists here in terms of the hope that things may change if you know, people speak up enough about it. Certainly the consultations I've had with FINTRAC and Department of Finance gives me hope, and certainly there are some people there who are pretty well versed in virtual currency. I don't use the word crypto, by the way. I think one of the things that needs a lot more thought is the $10,000 threshold. You know, the equivalent value of fiat value of a virtual currency, which can change by the minute. and also can be applied to 2,000 different virtual currencies. So how are you actually going to manage that? How are you going to report? If your exchange lists maybe 20 currencies, tokens, and you have to report, in the case of Bitfinex, pretty much every single one, because we have a $10,000 funding threshold anyway. Really? How are we going to do that? It has to be automated. And how is FinTrack going to receive it? And what are they going to do with it? Or do we just point them to the blockchain? I don't know. That's the one that I wouldn't say concerns me. I think that's too strong a word, but I asked the question, well, how are we going to do that?
I think that raises a good point, though, about having all these rules in place. We can talk about the things that concern us, but one thing that concerns me the most is how are they going to enforce them? They currently have to monitor more than 33,000 entities, and by all accounts of the Financial Action Task Force reviews, aren't doing a really great job of overseeing existing businesses. And they've added in this new business, whatever it's going to be defined as under dealing in, but they've also added in this foreign angle. And I've made the argument several times that it's really easy for FinTrack to walk down the street and come to Coinsquare and conduct an audit whenever they feel like it. And anyone in here, usually Canadian business people with Canadian-based businesses, FinTrack has a reach out to you that is rather simple. How are they going to go over to the kid in the basement in Malta and do a compliance review to make sure he's following everything that we have to follow? It creates a very unfair playing field, I think. In the Canadian market space specifically, if there's a Canadian regulator enforcing rules on Canadian-based businesses in a way that they cannot, and it is impossible to do globally. So, in adding new laws, are they actually adding, not that I want more enforcement, but, as a compliance person, it certainly helps to know that there's someone paying attention. And knowing that if we're doing what we're supposed to be doing, that the partners down the street, the partners in another place, are also doing what we have to do. And if they're not, and then it creates an uneven playing field again, a greater market share is easier to get when you don't have to be compliant.
Great. Now, it's great technology companies here. I know UCash is here and some great representatives from their company. What do you recommend, and I'm going to ask Amber first, what do you recommend that Bitcoin and blockchain companies are going to need to start doing to prepare themselves for, as I said, owners reporting and just the undertaking of a whole AML compliance program?
I think definitely start thinking about it. Start teeing up your technology. Start thinking about the types of information that you would have to collect and report. Start looking at your systems that you're using to identify people, because how you identify people under this regulation is very prescriptive. And there are things that you're probably doing that are risk-based, that are really good, that don't tick the box in terms of what they need to do. And so you're really going to have to start thinking about what things do we do both to protect ourselves from fraud and to truly know our customer and manage our risk, and to identify people according to this regulation. And those might be different things. I'm sorry, I know that all costs money. And in addition to that, if you don't already have a compliance person, start thinking about what that's going to look like. Is that an external hire? Is that someone from within your organization? And start getting them into that position now, where they can look at the organization and see what needs to change over time.
So basically, don't buy the Lambo just quite yet. Maybe start off with a Toyota Corolla.
Yeah, hiring a compliance person usually costs less than a Lambo, so,
Peter, I'm sure you would object. No, I'm joking. What do you recommend? Peter, coming from a large financial institution and kind of transferring over your skills and knowledge, what do you think that other cryptocurrency and blockchain companies are going to have to do to prepare for this?
Absolutely. I think Amber's already alluded to this. Really understand the process of how to conduct a risk assessment and how that drives your plan, your technology plan, and things like that. And one way of starting is absolutely to hire a compliance officer or have somebody within your function who either knows it already or gets up to speed on it by talking to Amber's company or whoever. To me, that's the starting point. That drives the plan. I think one of the biggest challenges for any exchange, for instance, is in the transaction monitoring piece of this world. What does suspicious activity look like in the virtual currency space? I can tell you that, in many ways it's very different depending on the nature of your company. So for a trading platform, for instance, rapid in and out movement of funds is absolutely perfectly normal. And it wouldn't be in a traditional banking space necessarily. Funds come in, funds go out. It's a totally different space, and as you know, Stephen and Charlene, we're starting to get together to understand what those indicators are in this space and actually compile them and take them to the regulators and hopefully make sense of them.
Jason, from a legal aspect, you hear a lot about using and getting compliance professionals, but with you saying that a lot of this will be settled and figured out in the courts, what do you think these companies should be doing maybe from a legal aspect?
Well, I want to pick up on a point that both Peter and Amber made. In terms of compliance, it's critical to understand what is going to be expected of you in terms of know your client and transaction records. There's really significant client identification and reporting obligations. So you got to get the name, address, phone number, piece of ID. If it's a business, you got to know the directors and officers of the business. This is significant for this industry, I think, and it's going to be a real sea change. So, two aspects of it from my perspective. One is the operational perspective. How are we going to implement all that? How are we going to collect the data? How are we going to keep our transaction records? How are we going to report? And that stuff all exists already in the banking industry or casinos or other large-scale reporting entities. So I think that infrastructure is available. But the more, I think, critical question for the virtual currency industry is strategically, how is that going to change my business model? And how am I going to adapt to that? And you can hire a compliance officer, but I think you also want to be thinking on a higher level from a strategic business perspective with your senior management team. How are we going to deal with all of this?
I think that's a really good point. Charlene, for a little boy or girl that looks at you and wants to start their own crypto exchange and they have Bitcoin dealer in their Instagram profile, what do you say to that person starting out that they should be looking to do first before they start updating their LinkedIn profile?
I wish you hadn't phrased it that way. Maybe we'll move it up to people in the space, but for a little boy or little girl, it'd be like, you better have some financial backing for this because it ain't going to be cheap. What I find I see a lot, and I have a long history of developing compliance programs for traditional money service businesses in higher risk business areas in my past as a consultant and working in-house at financial institutions. And I have to say that even those large established ones are still doing things piecemeal, a little bit system, a little bit paperwork, a lot of spreadsheets, PDFs, folders saved here and there. That's going to be really hard on a crypto to maintain and be able to meet these regulations. So there's a lot of young, smart people in this space, and getting as much automated and in the system to be able to pull data to put into fields for reporting, to put into fields for record keeping. So you're not scrambling come regulatory review time or just in general internal audit time to say, well, his name is on the system, but his address is on a PDF in a folder, and his phone number's in a directory, and his email's in a Zendesk box, and you have to pull all these things together to have this customer profile. So I think Peter makes a good point about the risk assessment, because you all start out wanting to do everything, and then you got to realize, well, here's what it's going to cost me to do everything, and here's the risks that everything is going to bring. So you have to set your risk appetite to say, what am I willing to do? What am I willing to invest in? You got to have these policies and procedures. It sounds like an easy thing to write. What I would ask is that people don't fall for a sales pitch of selling you 150 pages copied off the internet of FinTrack's website and call that a policy and procedure. You need to be able to operationalize this in your day-to-day business. And again, that brings me back to the risk part, choosing what market you're going to target, what the money laundering risks are there, and then for what controls you need to put in place. So some of this language about controls and assessment is newer in this space than just like, yeah, let's go get everything. And like, well, here's what the risks are that are associated with that. And here's the controls you need to monitor for potential money laundering, terrorist financing. Here's what you have to monitor for: regulatory risk, reputational risk, terrorist economic sanction risk. Might limit what you choose to do and where you choose to operate. But I think if I can leave one final point, maybe not for the kid, it would turn off any child from getting into this space. Data field mapping to requirements. What do you have in a system? What is required? Where are your gaps? How can I fill it technologically versus you're going to have to do some stuff on paper, because we can't automate things like beneficial ownership and signing authorities for business entities. But you can get pretty close if you have a lot of smart programmers and good people and good compliance people informing your compliance requirements.
That's amazing. And then can I kind of prompt you with the question of, how about these technology companies that state, you know, we're not touching the money, we're not touching the crypto, we're just a platform for these. What should they be preparing for based on these regulations?
Everyone wants to say it's not my problem. Whether or not your platform, what your business model is very much fact-based and really dependent on exactly what you're doing. And whatever words you're using to describe your business will only get you so far. So you really have to drill down and understand to what extent are you a technology provider versus an actual entity that's conducting business in the space. But I certainly want to reinforce the point that Charlene's making on the potential of RegTech solutions here. And also there was a consultation paper that was issued earlier prior to these regs coming out that suggested that FINTRAC's considering the idea of a regulatory sandbox. And if we're looking at technological solutions, that's certainly something that, in the future, if that's a path that FINTRAC goes down, would be really helpful to put forward in front of them. So I just didn't want to lose that point before we move on to say that RegTech solutions, I think, hold a ton of promise, and I think regulators are open to them to the extent that they're actually achieving the policy objectives that they want to achieve.
Just might not move as fast
Correct.
as people in this field. People in this field are very innovative. They want to move quickly, and the market moves quickly. You can't wait too long. But some of these things require thinking through. And I wanted to echo Amber's point as well about the KYC solution, because taking a selfie holding your ID is not acceptable under the current law and probably won't be going forward. Using biometrics is not yet available under the law. So all the new cool things that people are coming up with may not at this point be acceptable. So you got to think about that before you run off and build something that a regulator is going to turn around and say no to. And I hope that this sandbox can help push them. We have to help push them forward too. Not everybody's walking into a branch with their passport in their hand. It's not that model anymore. So the non-face-to-face rules in Canada are super onerous compared to most other countries in the world, and I think we're changing that, right?
Slowly. I think that's slowly getting better. I think the other side of that coin that I can't stress enough is don't look at the way that you identify someone under the regulations and think it's going to protect you from fraud, because you will get hosed so incredibly hard that you will be out of business. In order to identify someone under these regulations, you can match a credit file that has been in existence in Canada for more than 3 years with the name and address and date of birth of a person. So if we're friends on social media and you've been to my house, you can be identified as me under these regulations on the internet in a minute or less. Enjoy. Don't set yourself up for that. Know that you have to do something additional to protect yourself.
Maybe a couple of segues of interest to me is, one, your question was about a company that's sitting in the middle and, we don't touch any coin. We're sitting in the middle. So I think an analogy of that would be Backpage, who sits in the middle of the buyer and the seller for human trafficking, for instance, and look what happened to them. There were consequences there. And then the other segue was, as Charlene said, all the work that goes into collecting KYC, et cetera, and all this information and reporting information and things like that. And then you've got 3 days, once you form your suspicion, to file your STR in Canada. Well, I can tell you that any bank would struggle with that. certainly to put together a quality STR, certainly in the volumes that the banks submit them.
And it's 3 days, not 3 business days, right?
Yeah, 3 days. I mean, that's just impossible.
Yeah, but that's after analysis, right? So you have to do analysis. I took it as before some companies could deal with the 30 days.
We all play games with that time clock of like, it's not until you decide it's suspicious. We got to get FinTrack to be, and Department of Finance to be entirely prescriptive about when that start date begins. They can't leave that open for interpretation. They already do under the 30-day timeline, but we all play with that 30-day timeline. I find out about it. I don't know if it's money laundering. I need this much time to investigate it. At this point, I decide it's money laundering. Then the 30-day clock starts. They don't like that we play games with that, so I think they're trying to tighten it up, but I think that's a good avenue for us to challenge back in a professional manner.
Yeah, and you know, FinTrack's recently new strategy is intelligence for compliance, so STRs for compliance, and then intelligence for law enforcement when it gets to FinTrack. And you know, FinTrack have been very complimentary as to the quality of the STR submissions in Canada, particularly in human trafficking and other crimes. And you know, some of these are 6 pages long, really detailed analysis and very, very useful information that identifies, you know, previously unknown parties and things like that. And that takes time to put together. Even after you've formed your suspicion, you've done your analysis, to actually write a report essentially in the form of an STR, and you've got another 1,000 to do as well. If you're a bank, you know, that's a challenge. It might be different for a small exchange, for instance, somebody in a basement or something that submits maybe 1 a year or something. But
I think all this talk about writing STRs might be for some people in the audience, like, what is that even? You know, if you haven't had experience doing it, and Peter, you know, Peter's making a great point. FinTrack wants detailed intelligence, and if you've never seen one or done one, and there's no guidance out there about what that looks like, you might be like, I don't know, I think this might be something, and send it over. They're going to end up with, again, just like in banking, where they got a whole bunch of garbage in, and garbage in is garbage out.
We're talking a lot about how onerous these regulations are. So do you guys think, with a lot of companies and blockchain especially going to different countries to incorporate in headquarters, that these challenges in the amendments could prove to keep Canada away from being the blockchain hub that it should be? I'll start with Jason on this one.
Before I address that, I just want to stay on the suspicious transaction reports for a minute, because it's been a bee in my bonnet for a number of years. So a suspicious transaction report has to be filed where you as a reporting entity have reasonable grounds to suspect that someone's engaged in a money laundering or terrorist financing offense. So think about that obligation on you operating a business. That's a criminal code offense. So you're now interpreting the criminal code as somebody engaging in a criminal code offense.
Very good point.
Yeah. And it really ties in nicely back to our original discussion about the vagueness of some of the wording in these regulations. That is incredibly vague in and of itself. So that's never been resolved and still hasn't to today. And I'm waiting for the court case when I can help define that. But FinTrack has issued guidelines, pages and pages of guidelines on how you're supposed to determine whether something is a suspicious transaction or not. And there's over 100 indicators, for example, for some sectors. And I've seen one case where the reporting entity had monitored a particular customer as they came to the counter. They have surveillance video. They had a surveillance officer view that video, determine that they literally wrote a report that says there's nothing suspicious about that person, and then they were fined by FinTrack for failing to file a suspicious transaction report. FinTrack pointed to their own guidelines and said, oh, well, 3 of these 100 indicators, you should have identified 3 of these 100 indicators, and so it's suspicious. So when we talk about we want more clarity in the regulations and the Act, and when we want guidelines, we also want to be careful what we wish for. Sorry for the aside.
So it's when I read the reporting requirements, from what I read and understood, they're just codifying the guidance that's been provided to date as what data they would like us to have. When I also saw the interpretation of what is in those extra additional fields, most of them are optional. Because before we used to fill it into the other information field that
That would be for suspicious transaction reporting. They've just made more fields available on an already existing report that allows us to put cryptocurrency in there. But, the obligation to fill out the disposition in Section G about your story of what is suspicious, that's not changed. It's just a big, giant text block. So
I'm not sure I agree, and again, I'm speaking personally, not on behalf of anybody. I'm not sure I agree that those fields are optional. They're certainly labeled optional, and it's a bit like the guidelines. They're guidelines, it's not law. It's FINTRAC's interpretation of the law. But I can tell you, as somebody that's been involved in a number of regulatory examinations, they've become a regulatory expectation. And same thing as being law, basically, because you can get fined and things like that. So I'm not sure about the optional. If you have reasonable access to the information, then populate it.
Back to your question.
Yeah.
Sorry.
Jason, is this going to be the next blockchain island? Is what my question was.
Maybe others on this panel are better able to answer that question, but certainly there are jurisdictions where regulations are more lax or will be more lax after these are implemented. But with the requirement to be where a foreign entity is also regulated here, if you want to operate in Canada, then you're still going to be subject to these regulations, whether you're based somewhere else or not.
Charlene, how about you? Was it your choice to start in Toronto, Canada, or you just didn't want to move?
It was Coinsquare's choice, certainly, to start in Toronto and be a Canadian company, and my choice to join it. It raises a good point, though. I think some people would say, well, if you make it too hard, not just in cryptocurrency, but any kind of business, you make it too hard to do business somewhere, you're going to go somewhere else, and jobs can go, and Blockchain Island can sink, and Malta will succeed, and Switzerland will succeed. I do think it puts Canada at a great disadvantage if the laws here are well above and beyond other jurisdictions. I don't know that I would say the current laws are quite that far yet, but they have the potential to get there. And it's already requiring us to behave as though we're a bank without the resources, size, volume, money, profits of a large financial institution. But we all still need banks at this point in time. So if the law's not going to make us do it, the banks that we bank with will. So we don't necessarily have to blame the law for that one, because a bank won't give us services if we're too great of a risk to them.
How about you, Amber? Where are some of the jurisdictions that you've heard companies are going to, and do you think Toronto can compete?
I think that's a hard one to answer, because there's reality and perception. Regulation exists no matter where you are, and there are some jurisdictions that have really sought out to be more friendly, but you are still going to be affected based on where you have your customers, on where you have your staff, on where you have your office. So even if you're incorporated somewhere else, but everything that you're doing is targeted to people in Canada, I think that you're probably still going to be captured. But for people that have chosen to be here, that people that are choosing to open companies here, people that are choosing to stay here, thank you. I can't speak for everyone, but I love you. I'm glad you're here. I'm glad that there are services for Canadians. And please stay. Please keep doing what you're doing. We'll help you figure it out.
Peter, do you want to add to that about jurisdictional issues?
Yeah, I think you used the term blockchain island. To me, the blockchain's a bigger thing. Although if you want to understand the blockchain, understand Bitcoin, obviously. I think the potential for blockchain technology in Canada is huge, and it's already here, and we have some brilliant people probably in this room tonight, actually. But I separate blockchain technology from virtual currency. I think any company that wants to come to Canada, why would they? If the regulations are so onerous as you put it, and I'm not sure that they are onerous. I think that's a strong word at the moment. And I think you also have to distinguish between convertible virtual currencies in the sense of conversion to fiat, as opposed to virtual to virtual. I think that's a totally different thing, and a potential opportunity for Canada, for instance, in the trading space, CBC, virtual to virtual.
How about you, Anna? Do you see any more blockchain or cryptocurrency friendly jurisdictions that could pose competition to Toronto or Canada in general?
I do see it on the securities side. So on securities, I would see Switzerland and Singapore very much attracting entities willing to or wanting to do some sort of coin offering, for example. More frankly, because there's more certainty in those jurisdictions and more vagueness here. On AML, I don't think we're out of touch. I think we are, like other jurisdictions, grappling with how to do this. It would be nice if there was more harmonization, and I think that will come over time. But I'm not seeing Canada seen as an outlier in terms of being more onerous or more difficult to deal with. I think every jurisdiction, there's a struggle on how to apply AML laws in this context.
So I'll just ask you guys one more question before we go to the audience, because some of them seem like they're really looking forward to asking some questions. So de-risking, now that these regulations will come into place, it looks like the regulators are doing a great job of collecting information for reporting entities. Do you think there'll be a less chance of de-risking because a lot of these crypto and blockchain companies will be in compliance? I'll end with Amber because I know Rodney and David are going to jump on stage and jump in on the de-risking. So I'll start with Charlene and we'll work our way down the panel.
I have a very big bone to pick with de-risking. I mean, I went through it in the early 2000s with the original MSBs as, all the banks said, we just can't be bothered. It's too much work. Like, you have this risk and we don't understand it, so we're going to run away from it. A lot of banks got in trouble for just taking big swaths of clients and saying, we're not dealing with any Iranians because there's Iranian sanctions and we can't deal with the risk. We're just, I don't know, I call it old wine, new bottles. Like, we're the latest thing to de-risk. And cryptocurrency, digital currency, anything blockchain related. And I mean, I do think that's where regulation can help minimize our ability, or minimize anybody else's ability to de-risk us, like get us out of their business area, because right now the statements about us are, well, you're not regulated, and unregulated entities are of course always attractive to criminals, but that doesn't mean that every one of them is in fact harboring criminals, right? So I say you have to take you actually have to do the work to do risk mitigation, not avoid the risk. By becoming regulated, we have that, at least we have that in our pockets to say, we're not this Wild West that you think we are. Look, we're complying with the same rules that you are. Now, obviously, I'm speaking directly about financial institutions de-risking of the digital space. But I think it did a disservice to money services businesses post 9/11, back in the day. It's doing a disservice to us now. And this allows a step forward to say, we are regulated. We're not what you think we are, and we're following the same rules as you. And then institutions have to decide, are they going to take the risk, or are they going to continue to walk away from what is a growing, not going away market? Did I say that rant enough? I think, like, don't de-risk. I hate that term, de-risking. I hope you jump all over it. Right.
And do you see bigger financial institutions opening up their arms now to cryptocurrency exchanges as long as they're following these regulations, or is that a stretch?
I think opening their arms is certainly a stretch. I do think now at least there's some certainty and there's a regime, and entities can point to that. I know I've had some clients in the past that were in a stage that FINTRAC would not allow you to register because there wasn't yet the regulation. And so they were in an odd position where the bank would say, well, we think you're a money services business. And then FINTRAC would say, actually, you're not yet and you can't register. And then they end up in a very weird situation where it's hard for them to show the bank that they're properly supervised from an AML perspective. So I think it'll be helpful. It gives certainty. I don't think it'll be a wholesale opening of the arms. I think there's still a perception of risk in the industry. And I also think some of the aspects of the regs actually put a lot of obligation on the FIs when dealing with entities that are in this space. And so that's a lot of work. And depending on the size of the FI and the profitability of the sector, they may not be so incentivized to take on clients in this business line.
Piggybacking on that, Jason, what do you think in regards to the risk-reward trade-off for financial institutions dealing with blockchain companies?
Well, I think that's exactly, I agree with Hannah's point, that's what happened with MSBs, is of just you're not a significant enough player for us to assume the risk of trying to work with you, and so we're not gonna bother. I think we can look at it as a struggle or as an opportunity, and my fellow panelists are quite right that it adds certainty, it adds predictability, it adds a framework so that these businesses can operate together within an agreed upon set of rules. So if you can innovate and find the way to develop a platform that a financial institution will accept and incorporate, then that's an opportunity here for you to look at and as a way to adapt your business or grow in a different way. So I think this is a change, but it's also an opportunity to spawn a lot of innovation and new ideas. And as others have said, there's a lot of smart, innovative people in this room. So I'm looking forward to seeing what's going to happen.
Peter, helping build up RBC and BMO's risk and AML programs, do you feel that some of the financial institutions seeing people like you and Charlene in the crypto space will be more accepting to bringing in your exchanges to their portfolio?
I'm not sure about Charlene's exchange, but
Oh, come on.
yeah,
Good thing we're sitting between.
of course. No, I mean, Charlene, myself, and others are really putting together pretty robust AML programs, as good as any bank, basically, given the resources that we have, and to the highest standards of any bank, certainly in Canada. I think I've always seen risk as an opportunity. I see risk as speculative risk, not just a negative thing. Certainly certain banks in Canada, I think, would be very open to onboarding and are actively engaged in talks with various exchanges around the world about onboarding once regulations come in. I think any of the banks are afraid to go first, but definitely there's an opportunity there. And it also goes to the bank. I've just left a bank and put a great deal of effort, put 150 people through their CBP, and many of them trained with Block Geeks, the certified Bitcoin professional, to get people aware in the banks understand the risk, and then if you understand it, you can manage it. So I definitely think there's opportunity.
Amber, you recently completed a special project discussing de-risking. If you run this same special project where you're seeing how many financial institutions are accepting MSBs or similar cryptocurrency companies, do you think there'll be a huge change in the next 3 years?
I'm extremely cynical, but I very much want the answer to be yes. I hear murmurings of things that make me extremely cautiously optimistic. So there are a couple of banks in Canada that are actively dealing with cryptocurrency companies, openly dealing with cryptocurrency companies. And I think that that's excellent. I hear murmurings from the ones that aren't, that there is definitely an interest and that they are trying to figure out how to do that. So I would be thrilled if we turn a corner on that.
Perfect. I just want to say to the crowd, if we could just thank the panel for giving us such a great discussion. This microphone doesn't go very far, so if anyone has a question, maybe they can just stand up and try and keep it relative to the subject matter and maybe not go into their personal business model and how they can personally help you in the 20 seconds that you have for them to answer the question. Is there anyone that had something? Great.
Fern. Hi, Fern.
Charlene, this is just a point you made, so other people commented on it as well, so I'd be open to responses from anybody. But I was wondering if you could further elaborate on your comment on the de-risking or the disservice that de-risking of MSBs did to MSBs, like combination of the impact on MSBs, potentially the impact on customers.
Well, sure, yeah. And I think, back in the day when I was working in that industry, these were long-standing operating businesses that had, anywhere upwards of 30-year histories of banking relationships that suddenly overnight became persona non grata and were booted out. Obviously, that's a serious risk to their business operationally, and that they're not able to achieve their business. You know, it's a little bit opposite for the crypto space where people are just getting started and building these big ideas, and then it comes to a point where they need a bank and it's like, the door is shut. And like, what do I need to do to get in this field of regulatory uncertainty? I don't know if that sort of answers your question, but it's just a little bit opposite. But I think I always make this parallel to when Uber started. When Uber started, the taxi industry was super pissed off. They have a strong lobbyist group. Insurance companies were saying you can't drive your personal car for a business purpose. If you get in an accident, we won't insure you. They started cutting people off. Well, guess what? It took one insurance company to say, you know what, we'll insure you. We're going to charge you through the roof for it. Your premiums are going to be super high, but come here. And then the rest of them had no other choice but to do the same because they were missing out on a market share. So I think there is a lot of FOMO, not just in the digital currency space, but financial institutions saying, we don't want to get left behind, whether it's digital currency or anything blockchain based. You know, some banks may be saying no on the front of it, but in the back of it, they're sure working on it themselves and developing it themselves. I think it's an undeniable evolution that they're going to have to get on board for. It doesn't necessarily mean they're going to bank every exchange on the block or foreign ones that want to operate here under their new FinTrack MSB license. But I think, you know, to Peter's point of banks getting trained and taking the interest, it's going to take, you know, one of the good big ones to start opening their doors, and the rest will follow suit.
Yeah, I agree with that. And I would say that cryptocurrency companies, virtual currency companies, are way ahead of where MSBs were when de-risking started. To wit, when I started consulting, Charlene and I worked together, and at one point I was a banker before that, and I said, I don't know if I want to work with MSBs. I don't know if I'm interested in that.
We had a few interesting MSBs operating out of basements of people's houses in weird parts of town and doing strange things.
But there were also amazing ones.
Yeah.
And the first thing that she did as my colleague was brought me to a place where there was someone that served the community. It was remittance to a community that primarily dealt in cash in the recipient country because people were largely unbanked. And within the community in Canada, they did things like had legal services that were available in their own language because a lot of people were dealing with abusive situations.
They drove the bus every payday on Friday to pick up all the nannies to help them give their money to send overseas.
It was so... It was just a beautiful community that they had developed in terms of the additional services that they offered that had nothing to really do
with money,
but in terms of just building community, protecting people, helping them immigrate to Canada, helping them get in touch with lawyers that spoke their language. And it was incredible. And what I had thought as a banker was that money service businesses were all predatory, that they were charging higher rates than the banks, which is not true.
In all cases. In some.
In some, but I just didn't understand the value that these services were bringing to communities.
Until you see it, right?
Until you see it.
Probably the similar view in crypto, right?
Yeah. So
Peter Digital.
Yeah. So the service that you've done, Peter, and when you were in-house at the bank, I think is tremendous.
Yeah, maybe I could talk to that in a second. So. Again, I speak my own opinion. I recently worked for a major bank as the terminator, as was part of my role. So what I mean by that, chairman of the de-risking committee. And I can tell you that, you know, we took demarketing extremely seriously in the sense that it's not a blanket approach, that every case is different, every case is assessed against quite a complex matrix of risk, and I can't actually recall demarketing very many MSBs at all. And actually, the bank I just left was the one that actually kind of opened its arms to MSBs, and probably banks 80-90% of the MSBs in Canada, and so that takes me back to what can you do to prepare. So with my demarket chair hat on, you know, I would be looking at your AML program. I would be looking at your risk assessment, that you've actually done one, that you have your policies and procedures, and that you actually apply them. You do what you say that you're going to do. and it's operationalized. And if you do that in preparation for when the regs do come in whatever form, I think you've a far better chance of obtaining banking services and things like that, certainly with one certain bank that I'm familiar with.
Questions? Go ahead. Please stand up.
Can cryptocurrencies be used to violate sanctions, and is there a way to combat against that?
So the question was, can cryptocurrencies be used to violate sanctions, and if there's something that can be done about that? And we'll start off with Peter.
Absolutely. Of course they can. Any form of financial transactions can be used to violate sanctions. I can tell you that any exchange, probably every exchange in the world, is extremely alert to that. So, you know, as with a bank, you do your watch list scanning against the various sanctions list, you monitor the IPs, you monitor VPN usage, you do as much as you can to identify those sanctions issues. And probably in the crypto world, I'm just thinking out loud here, you might even have a better chance of detecting that maybe than in the banking world. But it really is no different from banking.
I will say this, though. If you are on a sanction list right now, you're probably not opening any accounts in your own name. So, you know, sanction lists are reactive, and people's names and business names are on them. And the people who are on them know they're on them, so they're not about to put their own name on something. We screen lists after the fact. And again, you know, I've been in this for a long time, and I can remember only a handful of actual hits when the list first came out. And you're like, oh, now this person's a terrorist. Okay, let's see what we have on them. From that point forward, there isn't going to be people. I mean, at least, you know, then you only catch the dumb ones, right? I mean, they certainly can be used, but I don't know that it would be as obvious. It's not obvious to banks because I don't think any terrorists are walking into banks opening accounts in their own names.
Yeah, if you're screening, if you're looking at IP addresses, you're probably not seeing a lot of traffic, by which I mean any traffic from North Korean IPs.
But we know they get money somehow.
Yeah, I think in the traditional space, you know, there's heavy use, I think, of trade-based money laundering type typologies, import-export, complex company relationships, shell companies, holding companies, things like that, to facilitate that sanctions breach. I'm not so sure if the crypto world is as friendly to that.
Can one of my lawyer friends talk about what the due diligence defense means in this case and how that would apply?
I'll leave it to the litigator.
Well, so if you're thought to have breached the Act or regulations, there is a defense where you can say I was duly diligent, which boils down to I took all reasonable efforts to prevent the offense, and I did everything that was required of me to monitor it. In theory, it's a defense available to you. In practice, it's unbelievably difficult and a high bar that the courts don't generally accept. So you don't want to rely on that as a defense. You want to prevent any non-compliance before it happens.
And with respect to sanctions laws, there's a lot of provisions that are strict liability, so due diligence defense would not help you.
So there's lots of companies out there that sell lists and make lists available, and it's one thing I look for when we are doing enhanced due diligence on other quasi-regulated at this time digital-based entities. You know, for anybody in this room who's building a business that has anything to do with the movement of funds, whether they be digital or not, screening is the first thing that I want to know that people are doing. It's, you know, again, it's not going to yield the output that we think it is, but the fact that you're actually doing it and you have enough information on your customer to be able to properly match or discount a potential hit, there's well over, oh God, I can't remember the last time I counted. I want to say over 6,000 names on the Canadian list alone, let alone all the global lists. Again, I'm not anticipating that you all are harboring terrorists in your platform, but like at a minimum, have a look it's called they require it on a, what is it, not frequent basis, but on a regular basis. You know, that's interpreted differently by different institutions. Banks do it nightly, if not hourly, if not minutely. You know, smaller, less risky institutions could probably get away with doing it weekly, but please do it.
Yeah, and I would also add to that sanctions laws apply regardless of whether or not you're an MSB, and that's certainly something. I do a lot of diligence for investors and other, you know, entities wishing to acquire.
If you're taking ICO money from someone from a sanctioned country or sanctioned entity or party, and then you try to convert that at, say, my exchange, I'm not going to really want that happening.
So yeah, that's certainly a gap that I see repeatedly, that entities that think that because they're not subject to the AML legislation, they're not subject to sanctions laws. That's not the case. Everybody's subject to sanctions laws.
We have time for maybe 2 more questions.
I get a little. It's fine to talk about what's allowed, but then we have the issue of like the FATCA regulations, stuff that's being imposed on Canada by the United States. Sort of a little bit of extraterritoriality. Does anybody want to talk about that? I mean, one classic example we have right now is like just marijuana law, which the banks are going crazy about trying to fund it.
Yeah, so I would say on that the U.S. has kind of an outsized influence on financial services regulation and probably, you know, regulation generally. So the fact that cannabis is not legal under federal law in the U.S. is what leads a lot of Canadian banks to be apprehensive about dealing with entities in that space, and the U.S. is very aggressive on enforcement, and they, as you say, they're very keen to be extraterritorial because they're really worried about that point of regulatory arbitrage where other jurisdictions may be able to do something and as a result gain an advantage. So certainly, you know, the U.S. and what's happening there remains always of high importance and has kind of an oversized influence on kind of the global regulatory landscape.
Anyone else want to chime in?
I just wanted to say that from a FATCA perspective, Canadian MSBs are not actually covered. So if you're operating a business that's going to be considered dealing in virtual currency and you're worried about being an MSB, you will not be a FATCA regulated entity.
Right, but I work for a charter bank.
Well, yeah, I'm sorry, the boot of American imperialism is descending on you. I can't help you there.
Yeah, they've taken out the definition of an EFT as a SWIFT MT-103, but in the consultations that we attended with the federal government, I haven't seen a clear definition of what they mean by an electronic funds transfer, because for those of you who haven't worked in this industry or in compliance and money laundering, there's a reporting requirement for international wire transfers, which were defined as SWIFT MT-103s that leave the country or come in from outside of the country. And they've taken out the MT-103 definition. And I think this is a bit sneaky because we're all focusing on the crypto stuff, but they've made little changes to other parts that have an impact on not only every other already existing reporting entity, but those of us who are wading into it new, that they haven't defined what they mean by electronic transfers, and does it mean bill pay, and does it mean, you know, Interac online payments, and, you know, that's...
It's a debit credit, right?
Yeah.
And I've had previous guys where they...
That's ridiculous. I'm sorry. There's no way that's even possible to automate. It's just, it's too much.
Oh, no, it's excluded. So
oh, it's excluded. Okay, sorry. No, because I... Yeah.
It's part of one of those 5 definitions. That it's actually excluded.
Well, domestic has always been excluded. It's always been international. But what they've changed is what electronic funds transfer means.
Well, they've expanded it, right, to include all the stuff that was in guidance. That was number 1. Number 2, nobody talked about the new monetary penalty, the 7 or 8 sheets of extended monetary penalty.
It's because they don't lay fines.
It they didn't even put it in the summary. They didn't say it in the summary that they've updated it. They just blocked it at the bottom. So you want to talk about that? I guess Jason is probably the better one. All the legal ramifications that cleared up the stuff in 2016.
Yeah, so we're talking about compliance. So what happens if you don't comply? Under the Proceeds of Crime Act and regulations, FINTRAC has administrative monetary penalty powers. They can fine you, among other remedies, but that's their first line of defense. So you'll get an audit, you'll get a letter saying you're deficient, and then they may further proceed with a notice of violation, and they'll list your deficiencies, and they categorize the deficiencies as minor, serious, or very serious. Minor is up to $1,000 per instance, serious is up to $100,000 per instance, and very serious is $500,000 per instance. So think about KYC obligations. You've got to collect all this personal information about somebody. If you don't collect their occupation, that's a minor violation. If you do 10,000 transactions a day and you don't collect occupation information for any of those 10,000 transactions, you could be cited for 10,000 violations. That's a big fine. If you, suspicious transaction report, which we were talking about earlier, is a very serious violation. So that can be a $500,000 penalty. And I'm aware of FINTRAC proceeding on a case where there was one failure to report one transaction, and they fined the reporting entity $500,000 for that one transaction. So you got 1,100 failures to record occupation, and you have one failure to report a suspicious transaction, you have a $1.5 million fine. Worst case scenario, right? And what we've seen, the pattern of FINTRAC's enforcement is they want to name and shame. So they want to set examples in various industries. They picked somebody in the casino industry. They picked somebody in the banking industry. There isn't too many major players in MSB, so they picked a bunch of littler ones and really went much harder at MSBs.
Because they couldn't have gone after Western Union, or?
It was easier. Well, they got a lot of pushback from the banks and the casinos, and so they went after the easier fish, which was the MSBs. And they could, could get people who couldn't afford lawyers, and then they got some fines that they could then publish and announce. So I would expect that this industry will face something similar, but the point was, I think Charlene's point earlier, is that there's no way they can enforce the entire industry and audit everyone, so they'll make some examples of people, and they'll try and move with a big fine so that everyone gets nervous about it.
Well, that's what I'm anticipating too, because they've been pulled off of the ability to fine. FINTRAC got in trouble because somebody challenged them on their fining regime previously.
That's my fault.
Yeah, 6 people. Well, there's a whole bunch more that we don't hear about, but there was one in particular that went all the way to the Supreme Court, that Kabul Farms, it's called. They were operating as an MSB and got a $6,000 fine for, not for laundering money, but for failure to have a compliance regime and various things under that. And they fought back, and then FINTRAC, it was called out that FINTRAC needed to pull back their fining, undergo an examination by the federal government committees to explain themselves, their mandate, their ability to achieve their mandate, how the fines contribute to, and enforce compliance in Canada. And what the result was that they're not allowed to lay a fine. I think it's been about a year, so they've got another year that are not allowed to lay fines again until they clean up the regime. So I think the changes that you're talking about that they dropped in is maybe some attempt to clarify.
Well, no, if you actually look at all of them, they actually now point out every offense, list minor, major, very serious, and they list them all up.
Yeah, because they were forced to. So they were forced to be.
Before they would say, we're referring to section 62, subparagraph 2H.
Yeah.
And
so what
it's in the reg, but it wasn't in the
what I anticipate is that they will come back with some vengeance to prove themselves, and like you said, make examples of some people, pick some maybe low or medium hanging fruit to say, you didn't think we were fining well enough before? Well, look at us now.
I think certainly if there are examples made, it will be with the lower or medium hanging fruit that can't tie up the process legally for the next 10 years. Having said that, FINTRAC's strategy, certainly under the past director, was one of measuring effectiveness as opposed to a checklist. you know, you didn't do this, you didn't do that, or you missed one or something like that. And certainly with Project Protect, you know, that was a big driver of that, and an assessment, not human trafficking, but an assessment of the effectiveness, say, of a bank's AML program, that they are trying to do the right thing. They are submitting, you know, numbers of SARs. They do have generally a good program. Okay, they missed a few things. I think there's some leniency built in there, and I'm not sure if that will change in the crypto space, in the virtual currency space. But if it does, it will be the low-hanging fruit, I think, that can't afford expensive lawyers like Jason.
That's amazing. So that will conclude tonight's panel discussion. I want to thank Amber, Peter, Jason, Anna, and Charlene. I want to tell you guys, if you go to the meetup group that Amber was talking about, there's some really good links to some of Amber's material on the subject, as well as there's an article from Anna, and there's commentary in the Bitcoin magazine from Jason. So there's about 6 or 7 pieces of documentation that these people are spending their whole weekends going through and summarizing for you. So it's a really good checklist to go understand the information and maybe bring back to some of the people within your company. Thank you guys so much, and let's enjoy the rest of the evening networking.
Thanks. I also wanted to say a big thank you to Block Geeks for hosting us and for filming, for generally educating the community and being awesome. We love you guys.
Take care, guys.